Hello, I'm attorney Tim Borchers, and this short video concerns the change in the law in 2020 concerning inherited IRAs. Inherited IRAs, also known as beneficiary IRAs, are what's left of your IRA or retirement account after your death. We're not talking about spousal rollovers of IRAs for the most part, because those rules have not changed. Your spouse can still make your IRA their own after you're gone. So this is primarily a change for your children and other beneficiaries. Under the old law, children could take a stretch of the IRA for their lifetime, creating small annual payments as a percent of the IRA. This was thought to be a great tax benefit. It also was protective of the content of the IRA against creditors and divorcing spouses, for example. But under the 2020 Secure Act, the beneficiaries are required to remove the contents of the IRA within 10 years. If that IRA is payable to a revocable trust, then chances are the provisions call for a conduit. All the conduit means is that the IRA has to pass through the trust and out to the beneficiary. This was done to qualify under the old rules. Under the new rules, the conduit effect would be that the entire IRA would be passed out to the beneficiaries within the 10 years. So if that's what your trust says, the beneficiaries have to get the money within that period of time, and this could be dangerous. The beneficiary could take the IRA distributions as a conduit over the entire 10 years. They could divide it into equal payments. They could take it all up front or all at the end if they wanted to. The problem is that if the amount that's going to come out is large, it's going to come out faster and with greater volume than ever before under the old rules. As a result, under the new law, the inherited IRA is all the more subject to being taken in a divorce by a creditor or being used up by the beneficiary very fast during a period of their disability or while they are, let's face it, destructive in their spending habits. Most of our clients simply don't want this result for their heirs. So we have a suggestion. And that is, for larger IRAs, you amend your plan to allow for the revocable trust to accumulate the distributions instead of sending them on directly to the beneficiary. By the way, if you have a standalone retirement plan trust already, like many of our clients, then this should also be amended. Still have questions? You probably should. We will try to record more explanations for you, but feel free to be in touch in the meantime. Thank you.